Mrs. Metz. And now we move to the final panelist in this second round, which will be Professor Francesco Maiani, representative of Odysseus Network. Please, the floor is yours for the next maximum 9-10 minutes so that there will be some ground for discussion. We still have 1 hour to go, and we still have to hear from the rapporteur and the shadows as we did in the first panel. The floor is yours.
Thank you, Mr. Chairman. I'm very thankful for the opportunity to present here. I've been asked to give an overview of the case law of the European Court of Justice on the Dublin III regulation. There have been 19 judgments directly on the regulation and a few more relating to it. This is more than double as those that were given on the Dublin II regulation over a longer period of time, which means that Dublin III entails much activity and has given rise to many questions which then come to the court. The issues dealt with by the court have ranged from the sublime issues of human rights questions to the nitty-gritty, everyday technical questions of the Dublin regulation. I, of course, have no time to go into any details about this case law, and what I will try to do is to present 3 important trends in the case law of the European Court of Justice, and you will all forgive my overlooking the nuances due to time constraints. The first trend is a higher level of protection. Karen Metz before me has made a great job to recall that the Dublin III regulation is much more protective of individual interests and rights than was the case of the Dublin II regulation. This was, to a large extent, the result of the EP involvement in the recast in 2013, and the European Court of Justice has honoured this change. The recast in 2013 has changed the way it reads the system. It used to read the system as a system of state-to-state interaction. It now interprets the regulation as one in which the applicant is a significant actor. I would like to point out that there is no contradiction between emphasizing rights and guarantees and ensuring efficiency, as is so often represented. In actual fact, one of the acknowledged causes of Dublin inefficiency is the fact that applicants are coerced into a system they don't understand. Making them part of the system and cooperation and make them cooperate with the system is one of the ways to make it more efficient, not less. 2, a second point emerging in the case law is a more balanced mutual trust doctrine. I here refer back to the principle as it has been exposed before. In actual fact, under Dublin II, and in particular in the Abdullahi judgment, there was a rather absolute idea of what mutual trust should be, one that made contesting a transfer contingent on being able to prove a systemic deficiency in the system of the responsible state, and this has created tensions with the system of the European Convention of Human Rights. It's demonstrably against some of the core guarantees of our common human rights heritage, and the European Court of Justice has taken the opportunity to correct this in a number of judgments, including CK and JAVO. And in JAVO, which has been criticized and praised, one can have different readings of it, the court has also tried to tackle one of the vexed issues of the Dublin system, one which is squarely out of the reach of a court of justice, and that is, what do we do with applicants who are reduced to extreme poverty in member states and try to move to other states to seek not only a better future, but better present living conditions. 3, one of the things that the court has done is trying to uphold the law in a situation of crisis. Again, the court may be criticized or praised for that, but one clear message it has sent is a crisis situation does not justify bending the law to interpretations which are unnatural and not what the legislator intended. You just have to go and read the Jafari judgment to get a clear picture of what I am referring to here. And in other cases, the court was confronted to, shall we say, procedural shortcuts taken by member states in the face of practical difficulties, and the message of the court was it at all times and under all circumstances the provisions of the regulation must be respected. And this is highly relevant now when there is so much pressure on actual compliance on the ground with the guarantees that are foreseen by the legislation. We hear of a multiplication of pushback practices, of informal practices, of workarounds around Dublin regulation. The message the court has sent, so far as the court can do, was this is not in keeping with the spirit and the letter of the Common European Asylum System legislation. So I come to my final remarks. Overall, although I may have painted it a bit too rosy, but when you have 10 minutes, you have to make choices. But there have been more thorns that I have said in the case of the European Court of Justice, but overall, it's been a positive contribution. And the same could not be said, I would say, without reservations, of the European Court of Justice contribution under the Dublin II regulation. So there has been a distinct change in here. And the case law of the court demonstrates that there are margins to interpret and apply Dublin III in a way that is more humane. And I would like to stress that there are in particular vast margins of improvements in the application practice in everything that concerns the protection of family unity under the Dublin regulation. Another point is that, of course, as the court gets the opportunity to clarify the many aspects of the Dublin regulation, and it's something that takes years, decades. In internal market law, it has taken decades to clarify some points. Well, as the court does this can have a positive impact on efficiency. Let's all be sure of this, a marginal impact, because the causes of inefficiency are not just doubts of interpretation, they go far deeper into the structure of the Dublin system. And this leads me to my very final point, and I notice that I still have 3 minutes and a half, so I'm good with that. The objection that could be made to me is, well, the court has done a positive contribution, but it doesn't work. We need to reform it. Good. So let me take the opportunity to express a couple of ideas about all that we've heard about the reform of the Dublin system. Sure, it would be a good thing to reform the Dublin system, but the reform has to be a reform for the better. We have to make sure that we do not worsen the situation, but rather that we improve it. And in this case, let me ask a few questions. First of all, could any conceivable system of responsibility allocation work if we have not yet proven that we are able to enforce our common standards? Aren't we getting the priorities wrong here? Don't we have to first prove that we are able to enforce the common European standards before we bring the patient once more on the surgery table? Second, are we able to have a system of responsibility allocation which is capable of functioning when every member state has to support the cost of every marginal applicant, when we are unable to bear those costs together? These are the factors that give the bad incentives to the actors who participate in the system and make it impossible to operate Dublin fairly. Another message, let's forget that there is a legislative silver bullet somewhere there. Allocating responsibility in the European Union is a feat of staggering complexity. So we cannot be under the illusion that with a legislative fix we will have solved all the problems. 3, I hear a very strong current in favor of distributing applicants fairly and equally, and who could be against that on paper? But my question is it even feasible on an EU-level scale to relocate applicants by the hundreds of thousands across the member states without bothering to have their cooperation in that? And last point, let me ask naively, because we've heard this in the debate, why are secondary movements the focus? If I read Article 78 of the treaty, as I understand it, the focus is that Europe as a whole honors its protection responsibility, examines the application quickly, and returns those who do not have a need for protection while integrating those who have a need for protection. Well, if that is correct, improving our ability at state-to-state ping-pong will not help one bit. Thank you very much.